Many of you will have seen this story, and indeed many of you have tagged me in comments and threads about the man who was arrested for burning the Quran. Now, obviously this has raised a lot of serious questions about criminality and so on, because as I've mentioned in previous videos, we don't have a blasphemy offence in the UK. So I'm going to talk a little bit about that in this video and what offences, if any, this might give rise to. But I do want to say at the outset, this is probably one of the rare occasions I agree with Keir Starmer. For what it's worth, I do think that burning religious texts is awful and should be condemned. But does that give rise to a criminal offence? That's not so straightforward. So regardless of what your personal views are, I would encourage you to watch this with an open mind, an open view, and listen to what I have to say about the law generally. But obviously this is not to be taken as legal advice by anybody, and is certainly not designed to encourage anybody to engage in this sort of activity. So I want to make that absolutely clear before I even enter this discussion. And as a final caveat, of course, I'm not giving any particular opinion on this one case as it happened. I've deliberately not read too much detail about it, so I'm just going to give a generic discussion as to the law that might apply in cases like this that happen in public, so that we can have a legal discussion as to what offences may or may not apply. So first of all, if you're new to me, I'm Daniel Shendsmith, a barrister of England and Wales. I enjoy helping you to understand law on this channel. I've been doing it almost every day now for 5 years or so. So please do subscribe to the channel if you like this open, objective, neutral, independent, and hopefully unbiased approach. I don't always succeed in being unbiased, but we're all human. So let's take a look at this then, shall we? I'm not going to play any of the video or any of the clips for obvious reasons, not least of which out of respect to those that might be upset by it. Because as I've said, I do think it's awful. I do think it should be condemned. I don't support it. But whether it gives rise to criminal offences or not is an entirely other matter. And that is not so straightforward. To give you a comparison, an example that we'll talk about throughout this video, many of you will have seen videos and reports, etc., of our British flag being burnt at various places, and in some cases, in the worst of those cases, at centre paths and the memorials and things like that, which again is awful. So let's have a look at what might have actually happened here. Now, the police responded very quickly to say that, and quoting Assistant Chief Constable Stephanie Parker here, said, quote, "We understand the deep concern this will cause within some of our diverse communities and are aware of a live video circulating. We made a swift arrest at the time and recognise the right people have for freedom of expression, but when this crosses into intimidation to cause harm or distress, we will always look to take action when it's reported to us." Now, breaking that apart a bit, she talks of intimidation, she talks of causing harm or distress. And so let's take a look at what possible public order offence this could be. Now, public order offences are, as it might, the name suggests, under the Public Order Act of 1986, we've got a few different offences here. The most common one that people will be familiar with is fear of provocation of violence. So the standard public order offence is putting someone in fear of provocation of violence. A person is guilty of an offence if he uses towards another person threatening, abusive or insulting words or behaviour, or distributes any writing, sign or representations, etc., which is threatening, abusive or insulting. But in this section, the standard Section 4 offence, the important bit is here, with intent to cause that person to believe that immediate unlawful violence will be used against him or another by any person, or to provoke an immediate unlawful violence, etc., etc. So this Section 4 requires the intent to cause the person to believe immediate unlawful violence, etc. Section 5, skipping 4A for a moment, which I'll come back to, jumping ahead to Section 5, harassment, alarm or distress. A person is guilty of an offence if he uses threatening or abusive words or behaviour, or disorderly behaviour, or displays any writing, sign, etc., within the hearing or sight of any person likely to be caused harassment, alarm or distress thereby. And it is a defence to this charge, first of all, that they've no reason to believe that any person within hearing or sight, obviously that's not relevant here, or that is inside a house, which is not relevant here, or the third one is that his conduct was reasonable, which I will come back to in a moment. Moving back to the section 4A offence, which is drafted in intentional harassment, alarm or distress. This is subtly separate, which is a person is guilty of an offence if, with intent to cause a person harassment, alarm or distress, uses threatening, abusive or insulting words or behaviour or disorderly behaviour, displays any writing, sign, etc., thereby causing that other person harassment, alarm or distress. Now, either section 4A or section 5, could somebody be caused harassment, alarm or distress in either of these sections? Well, arguably, yes, they could arguably be caused harassment, alarm or distress in that area by somebody burning a religious text and so on. So as a brief recap, section 4, a person does any of those things with intent to cause the person to fear immediate unlawful violence. Section 4A, they do any of those things and intend harassment, alarm or distress, which if it's a simple protest, that might be difficult to prove and thereby causing that person harassment, alarm or distress. Section 5, which may be more relevant here, is where a person is guilty of the offence if they use, and in this case the most appropriate would likely be behaviour or disorderly behaviour, within the hearing or sight of a person that is likely to be caused harassment, alarm or distress. However, just like in section 5 under section 4A, there is a defence available, again if it's in a house, which is not relevant here, or that the conduct was reasonable. So what does that actually mean? And even more so, what could this actually amount to? Now, the act of burning a religious text in a public place is obviously some sort of protest, some sort of expression of views. Now, the protest bit is key here, because whenever there is an overlap with an offence and a human right aspect, which in this case the right to the freedom of expression, if there is an argument under reasonable conduct, which remember is one of the defences available, if the defendant, and the burden of proof is on the defendant to raise this defence, so all you have to do is you have an evidential burden, not the burden of proving, but an evidential burden to raise that this is reasonable conduct. Then to show on the balance of probabilities that the conduct was reasonable. And so if the argument there was, well, this was because it was a protest of some kind, then the defendant may raise that that is a reasonable conduct. However, then, as I say, if the rights are engaged, including the right to the freedom of expression, which includes the expression of religious beliefs and etc., or the right to protest and so on, it is then for the prosecution to prove beyond a reasonable doubt that the interference with that right to prosecute somebody for an offence of public order is proportionate. So just to reiterate that, it would then be for the prosecution to prove beyond any reasonable doubt that it is proportionate to interfere with the rights of the individual to prosecute this offence. And this comes from two separate cases. There's the Crown on an application from the DPP against Manchester City Magistrates Court of 2023, and also when there is a consideration of another human right, Article 9, freedom of thought, conscience and religion, together with the freedom of expression, ACHR. This comes from another two cases, Dell and the CPS, and Hammond and the DPP of 2004. Dell and the CPS was 2005. And so it may then be possible for a defendant to establish that conduct was reasonable with the consideration of each of these articles of ECHR, the freedom of expression, Article 10, and the freedom of thought, conscience and religion of Article 9. And so if it was raised as a defence in one of these cases where the conduct was reasonable with reference to these rights, the right to the freedom of expression and the right under Article 9, freedom of thought, conscience and religion, that is only an on the balance of probabilities objective test. Was it reasonable in the circumstances? And then if that's raised as a defence in cases like this, it shifts back to the prosecution to prove beyond a reasonable doubt that it's proportionate to eliminate those rights in order to secure a prosecution. Now, obviously, then the court would have to make a determination, and if that's the magistrate's court, it would be the magistrate's bench that would do that. If it's in the Crown Court, a jury would have to do that. And then is a question and a finding of fact. And that is what would happen in any of these cases if indeed they were charged with a public order offence. If successful, then the fact that it has to do with race, religion, etc. would make it an aggravated offence. Just a few other questions as well. This conduct complained of need not be directed towards another person, and whilst the prosecution must prove that someone else was able to see or hear the conduct, they don't need to adduce evidence that that's actually been seen or heard. Obviously, in most cases, that's not going to be relevant anyway. It is not necessary that the words or behaviour have actually caused harassment, alarm or distress, although where there is clear evidence that it has, that makes it easier to prosecute a case like this. And as to intention, a defendant must intend that their conduct is threatening, abusive or insulting or disorderly, or be aware that it is. And this will be a subjective assessment on any defendant's state of mind, given the circumstances, the conduct, and the evidence surrounding those circumstances. And so in all likelihood, if someone is doing something very specific, it is likely that they know why they are doing it and that they know that they are doing it for a particular reason. But as I said, this is where that balancing act comes in, because it is a very delicate balancing act between maintaining the right to the freedom of expression, and expression doesn't just mean, most people think expression is talking and shouting or whatever. Expression is not necessarily talking. Artists will be familiar with this. That's why it includes, that's why the offence includes behaviour and conduct, etc. But expression can be to express yourselves in a number of different ways, whether that's drawing pictures, holding a flag, or whatever it might be. So on the one hand, we have the freedom of expression, which is, especially if it's political, etc., it is fiercely, or should be fiercely guarded under our law. We also have the right to the freedom of religion, of thought, and etc. And so the combination of those is where we have the right to protest, right to peaceful protest, and all those kind of things. And so that is the balancing act. We have those set of rights, and then the question, is it proportionate to eliminate those rights so that we can prosecute somebody for the offence? And so the obvious problem here, if they were to prosecute this kind of behaviour, is that it very possibly gives legitimacy to the criticism of two-tier prosecutions. Because where do we draw the line? Because if somebody is, let's say, waving the flag of another country in protest against what the United Kingdom is doing overseas, to speak very generically, if they were marching, waving a flag, which is conduct and behaviour, and let's say that their intent is then to cause a person harassment, alarm or distress by waving said flag, then if they thereby caused somebody alarm or distress or etc., that obviously then has to be balanced with all the rights that I've just explained, the right to the freedom of expression, the right to the freedom of religion, etc. And so if they were to prosecute this, then they ought to prosecute that. Now, I accept that waving a flag is very different than burning a text. And as I've said, I don't condone the burning of a text. And they are very different, but the principle is precisely the same. If you were to prosecute one and not the other, that would give legitimacy to the argument of two-tier policing, two-tier prosecutions, etc., which I don't accept that we should have. I suggest that it should all be policed and prosecuted equally and fairly. And the police and the prosecution doesn't always get that right, but that's not to say that that's the intent to do so. Sometimes they are open to criticism for what they do. But that is the problem that I would see with prosecutions like this. Finally, one other question that popped up, why is it not criminal damage? Well, it is not criminal damage to destroy your own property. Crucially, the definition of criminal damage is property that belongs to another, and that includes by burning your own property, which is why you can burn your own things by way of bonfires, making sure you stick within all the bylaws of your local authority, etc. The exception there is if it's property that creates a risk to somebody else. So under sub 2, section 1 sub 2, a person without lawful excuse destroys or damages any property, whether belonging to himself or another, intending to destroy it, and being reckless as to whether the life of another would thereby be endangered. So even if it's your own house and you set fire to it and it's reckless that someone else might get injured, and then that would be the arson variety of criminal damage, because regardless, it's your property. If there's risk to life, that makes it arson and criminal damage. But generally speaking, you cannot criminally damage your own property, or even if you reasonably believe that the owner would consent to such damage. The example there is you're walking down the street on a hot summer's day, there's a dog or a baby or somebody in the car that looks like they're in danger. If you were to break the window to free that person, then arguably you would reasonably believe that the owner of the property would consent to it to save the dog, the baby, the person, etc. So even though it would ordinarily be criminal damage, it would be a defense if you showed that it was reasonable to believe the owner would consent to the damage. But obviously, in general cases that we're discussing on this video, that wouldn't apply. If the person owns the book themselves, then criminal damage in the traditional sense doesn't apply. So as I say, I hope this comes across as a balanced discussion and argument. What the issues would be with prosecutions like this. This is, again, just a generic legal discussion, not commenting specifically on that one case, although, as I say, it's difficult to separate them out, but it is not intended to interfere with that case in any way whatsoever. But do leave me your thoughts and comments respectfully in the comments box below, please. Please do remember to like the video, share the video, subscribe to the channel. That helps the channel grow. And as always, thank you for watching.